This is case 2019-0099, State of New Hampshire versus Kyle Perkins.
May it please the court, I'm Joshua Gordon. I represent Kyle Perkins. The Constitution guarantees a reasonably present and reasonably competent lawyer. And Attorney Keith Matthews failed in both these regards in three ways. First, he didn't really pay attention. In public defender training, you learn to make a list of the elements of the crime, listen to the state's case, check off each element as the state proves it, and make a motion to dismiss on the weakest one. Matthews didn't do this. He didn't notice that the state missed an element of value. And there's no conceivable strategic reason for not asking for dismissal after the state.
Well, Judge McNamara disagrees with that view. That there was anything lacking at the end. If there'd been a motion to dismiss at the end of the state's case, Judge McNamara says that wouldn't have gone anywhere because there was enough evidence.
Judge McNamara
Why is that wrong?
I think Judge McNamara is wrong, and had this issue been preserved for appeal through a motion, may have prevailed on appeal because in Judge McNamara's order, he says that he recollects that the officer did some research about the value of iPads at the time of the theft. And there is nothing in the record to support that. The only evidence of value is the purchase price that the school paid for the iPads in 2011, 4 years before the receiving, and that's the only evidence. And Judge McNamara just misremembered the evidence, and I think you'll see that from both Kathy Green's motion to set aside the verdict. She has all the evidence of value appended to it, and in the record at large.
And it's not enough. My recollection is there was some testimony as to the condition of the iPads very close to the date of that we're talking about here, the date of valuation. Why isn't that and the purchase price sufficient to get it to a jury?
Well, the jury didn't. Well, the jury didn't know. For the second allegation of error here is the jury had no way of knowing what the law of value was. The jury could have assumed, a reasonable juror could have assumed that purchase price was a reasonable valuation, or the existence value for the kids to educate themselves with an iPad, or resale value or replacement value, and none of those are the measure of value. Value has to be measured at the time of the crime, the time of the receiving, and it's an arm's length appraisal. And the jury had one data point, which is the purchase price. In all the other cases that this court has decided, there's many data points. In Hamill, the stolen car case, there was an expert who testified. In Belanger and Moody, the older cases, there was the price the thief got for it after the crime.
So if I bought a car for $50,000 3 years ago and it gets stolen today, and I come in and say it was in fine shape, that's not enough?
Well, no, it's not enough to know what the value is.
To know that it's more than $1,500, that's not enough?
Pardon me?
It's not enough to satisfy the burden of establishing that it's more than $1,500?
Well, if let's say you bought a car for $1,200 or something very close to this amount, and the issue was you don't know how much the value is, and it matters, what it was worth 4 years ago isn't sufficient data to know what the value is today. And purchase price isn't the measure of value. It's at the time of the crime is the
But
value.
it's a piece of relevant data in figuring out the value at the time of the crime.
Absolutely relevant and admissible, but not sufficient. And that if that's the only data, that's not enough. Then the state didn't put in enough evidence.
So again, my hypothetical: if I bought a car 2 years ago for $50,000 and it gets stolen a month ago, and the testimony at trial as well, it was in good shape. I drove it a normal amount of time. That's not enough to satisfy the state's burden?
I don't think it's enough to satisfy the state's burden. And in Hamill, that's why there was an expert and, testified what the value was at the time of the crime.
Now, the state argues that Detective Wormersley testified that he researched the value of stolen iPads in 2015. Did that happen? Did that testimony come in?
It did not happen. Wormsley testified that the only basis for his knowledge of the value was from the school, and it was the purchase price. He misstated it. He said $429 rather than $479, but nonetheless, he said very clearly that that was his only basis, was from the school. He researched the value of some parts and unrelated things, but not the value of the iPads.
Remind me here, how many iPads are we talking about?
26.
26, and so the value per iPad we're talking about is $40?
If it's $40, it doesn't reach.
If it's $50.
If it's $57 and change.
Okay, all right, so that's the threshold here, really.
Yes,
And Attorney Matthews told the jury that they were worth between $50 and $60 apiece, and that's really your argument, right? That he gave the jury the basis for the conviction.
My client gave the jury the basis for the conviction, and that's the third allegation of error here, is that, whether or not it was a good decision to put the defendant on the stand, going ahead and asking the one question that filled in the hole in the state's case is just ineffective assistance.
Well, the testimony of counsel was that he didn't expect that answer, that he thought the answer was going to be nothing.
That does not borne out from his opening, and if he knew the law, that the issue was how much was the value at the time, he would not have asked the question. He wouldn't have put the man on the stand. He would have made a motion for directed verdict after the state's case. And he did none of these things. He didn't even ask for an instruction with the accurate statement of the law. So a juror could have thought that value could be the value of education to a child in school. There's just no basis for a juror to make a rational calculation of value. And so he did a series of three things. He didn't make a motion for directed verdict when the state didn't have any evidence of value. Then he asked his client the question that filled in the gap, and then he didn't ask for an instruction with an accurate statement of the law.
But on the second issue, the client, there's no testimony from the client, no affidavit from the client on that issue of what the expectation of the trial testimony was going to be.
You mean
right?
in the ineffective assistance proceeding?
Yes.
No.
Okay. The only testimony on that point is from counsel.
The only testimony, it's an affidavit from counsel, yeah.
Okay.
There's no other questions.
Thank you. Ms. McGinnis? Thank you, counsel.
Submitted.
Case submitted.